Hello friends, in the series on the income tax cases, today we will discuss a case with the objective that it should give a learning both to the revenue or the assessee that any party should not try to give any false evidence or false affidavits in the income tax proceedings. The issue before the Kolkata ITAT B bench in the present case was that if the revenue shouts to condonation of delay for filing the appeal on a wrong affidavit which is factually wrong, so whether in that case the appeal of the revenue should be admitted. This issue has been taken up by Honorable Kolkata ITAT B bench in the case of Income Tax Officer versus Alert Consultants and Credit Private Limited. This case is reported in 121 ITR Tribunal Short Note 65 and the date of the judgment is 25th November 2024. The facts of the case are very interesting. In the present case, when the matter was before the CIT appeal, the CIT appeal gave direction to the assessing officer to examine the genuineness, creditworthiness and identity of the investors who have invested into the assessee and also to verify the valuation report of the shares of the assessee and then pass the order accordingly. When the assessing officer received this order of the CIT appeal, then the assessing officer, without going into the appeal against this CIT appeal order, proceeded to verify the genuineness and creditworthiness of the investors and accordingly passed order in favor of the assessee. It was very clear from the date-wise orders of the assessing officer that the assessment record was very much available with the assessing officer. When the verification was done, order was passed. After that, the revenue filed the appeal before the tribunal with a delay of 130 days. And when the question of explaining the delay came, the revenue took the plea that since the assessing officer was not having the physical copy of the CIT appeal order, that is why there is a delay of 130 days. The tribunal said that in the present case, from the order sheet it is very clear that after receiving the CIT appeal order, the assessing officer proceeded to verify the 3 tests of the investor companies and even he passed the order. Then in any case it cannot be said that the assessing officer was not having the order of the CIT appeal, meaning thereby that the affidavit which was given by the assessing officer for seeking the condonation was factually wrong and it was on false facts, and this mistake was done intentionally by the assessing officer. So the tribunal rejected the condonation and dismissed the appeal of the revenue. Even on the merits, the tribunal said that in the present case, even if this matter will be remanded to the CIT appeal, because the plea of the appeal of the revenue was that the CIT appeal was not having the power to remand back the matter to the AO, and the CIT appeal should have passed the order by seeking the remand report from the AO. So the tribunal said that even if this matter will be remanded, then the CIT appeal will decide the matter on the basis of the remand report of the AO. So it will not make any difference that even if this matter is remanded back to the AO. So the tribunal was of the considered view that in the present case there will be no useful purpose will be served by again remanding the matter to the CIT appeal, and it will be a procedural formality resulting in wastage of time, and at the end the tribunal completed the order by saying that in the present case the court is refraining itself from recommending any disciplinary action against the AO. So this was also a sarcastic comment on the AO because the disciplinary action was not taken. So this case gives a message that we should not try to give any wrong affidavit, or while we are giving the affidavit we should be very sure that we are not giving our affidavits which are factually incorrect or false. At the end of this video, once again, I am repeating the name of the case. The name of the case is Income Tax Officer versus Alert Consultants and Credit Private Limited. And this case is reported in 121 ITR, Tribunal Short Note 65. And the matter has been decided by Kolkata ITAT B bench on 25th November 2024. Thank you, friends.